the Honorable Deputy Attorney General and Minister of Justice, the Honorable Justice Rimsai, my lords and ladies, Justices of the Superior Court of Judicature, my honors, Justices of the lower bench, Mr. President of the Association, His Lordship, Justice Henry Kofi, Madam President of the Ghana Bar Association, the Acting Director of the Ghana School of Law, and my former employer, Professor Raymond Atoguba, colleagues from the bar, ladies and gentlemen, good morning. I want to begin by assuring Mr. President of the Association that unlike the former Chief Justice, I will not issue a rebuttal this morning. I have noted down the challenges confronting the judiciary, and all of you who have worked with me, at least at the level of the Judicial Council, know how passionate I am about the comfort of our judiciary. When I was Deputy Attorney General, I made it a point not to allow Her Ladyship, the Chief Justice Georgina Wood, or the Judicial Secretary to make contact with the executive branch of government. I took up all those problems and walked directly to the Ministry of Finance to see to it that things are done. And that is the attitude that I bring again to this office. I'm going to work assiduously with my deputy for us to ensure that the challenges confronting the judiciary are a thing of the past. I know that as a country, we don't have a lot of resources, but I'll be coming to you to help me raise resources that will be plowed back into the welfare of the judiciary and the country as a whole. I must say that it is an honor to join you at this important gathering of the custodians of justice in our country. On behalf of His Excellency John Dramani Mahama, I extend warm greetings and reiterate the government's unwavering commitment to a robust, independent, and effective judiciary. Let me first commend the leadership of the association for choosing such a timely and forward-looking theme, that is leveraging technology for justice delivery in Ghana. This theme underscores the critical need to ensure that justice and the processes by which it is delivered keep pace with the digital transformation reshaping every phase of human endeavor. We meet at a time when the world is undergoing rapid digital transformation. Every sector, finance, commerce, education, health, and even politics, is being reshaped by technology. The administration of justice cannot be an exception. If the costs are to remain relevant, accessible, efficient, we must embrace innovation and harness digital tools in a deliberate and structured manner. Our courts are revered for their independence and fidelity to the Constitution. Yet, we must acknowledge candidly that justice delayed is justice denied. Prolonged adjournments, missing dockets, and mounting case backlogs continue to erode public confidence in the justice system. This concern is not new. In Republic versus High Court Commercial Division, Accra, ex parte Attorney General, NML Capital Limited, the Supreme Court underscored the need for expeditious handling of matters to prevent abuse of judicial process. Similarly, in the celebrated case of Mensah and Attorney General, the court reminded us that constitutional rights lose meaning when enforcement is trapped in procedural delays. Technology offers us the tools to meet these challenges. E-filing systems can be used to eliminate the phenomenon of lost dockets. Virtual hearings can be deployed to widen access to justice, especially for litigants outside major cities. Digitized law reporting, for instance, Danish law, gives judges lawyers, and citizens timely access to judicial precedent. Case management platforms can be used to track timelines and reduce adjournments. Ladies and gentlemen, permit me to acknowledge some initiatives that we have already undertaken as a country. The e-Justice project, which has digitized the operations of selected high courts, marks a crucial first step. The Judicial Services use of virtual court sittings during the COVID-19 pandemic and now during legal vacation demonstrates adaptability in times of crisis. My office, in partnership with the Ministry of Communications and Digitalization, is expanding online legal research resources to ease access to statutes and case law. These steps echo the foresight expressed by the Supreme Court in 2004 and Attorney General, where the court recognized that the Constitution is a living document adaptable to the demands of a changing society. Our justice system, likewise, must evolve with time and in tandem with advancements in technology. We must also be frank about the obstacles before us. The first and most prominent obstacle is a gap in infrastructure. Many courts, especially in rural areas, lack reliable internet or even basic IT equipment. And I think that the president of the association underscored this point when he talked about the fact that you lack many of the tools, especially the technological tools that you need to be able to work. The second is what I will term the capacity constraints. Judges, magistrates, registrars, and lawyers require continuous training to operate digital platforms effectively. The third obstacle relates to the cybersecurity risk, which has been underscored by the president of JUSAC. The integrity of judicial data is non-negotiable, but may be compromised if vulnerable to hacking and other cybersecurity breaches. The final obstacle is in relation to legislative gaps. Our Evidence Act and procedural rules must be updated to recognize electronic documents and remote proceedings as standard practice. As Attorney General and Minister of Justice, I am committed to collaborating with the Judicial Service and His Lordship the Chief Justice and Parliament to modernize our procedural laws and align them with technological realities. My lords and ladies, to fully harness technology, I propose 5 priorities. First is a nationwide rollout of e-filing and e-justice platforms to cover all the courts in the country. Second is the institutionalization of virtual hearings in appropriate matters, especially commercial disputes and interlocutory applications. Third is the creation of central digital legal knowledge hub containing statutes, practice directions, and case law. The fourth is a targeted training program for judges, magistrates, and staff on technology, and digital technology. And then the fifth is the public-private partnerships to mobilize funding and expertise for judicial digitalization. Let us remember that technology is only a tool. Its effectiveness depends on our collective will to use it with discipline. Judges must be open to new methods. Lawyers must adapt their practices. And the state must ensure adequate resources are made available. The hurdle that needs to be crossed is how technology is used to enhance justice delivery without compromising its quality. With the advent of artificial intelligence, some lawyers have relied on non-existent authorities to support their cases. And I don't know whether this has happened here, but there are reports of it happening in other jurisdictions such as the US and the UK. In the case of Allende, R versus London Borough of Haringey, that is a 2025 reported case, EWHC 1383, Dame Victoria Sharp said as follows: there are serious implications for the administration of justice and public confidence in the justice system if artificial intelligence is misused. Even though artificial intelligence can be used to resolve issues, it is a tool, and it must not take away the industry of the lawyer, the magistrate, or the judge in conducting legal research. The integration of AI into justice delivery presents opportunities and risks. While AI tools can compress hours of legal research into seconds, their outputs must always be subjected to human scrutiny and verification. Judges and magistrates bear the solemn duty of ensuring that technology supports rather than supplants judicial reasoning. To this end, it is imperative to establish a clear regulatory framework to guide the responsible use of AI in our courts, one that safeguards accuracy, integrity, and public trust in the administration of justice. In Republic versus High Court Fast Track High Court, Accra, ex parte Commission on Human Rights and Administrative Justice, the Supreme Court validated the establishment of the Fast Track High Court as a constitutional innovation to quicken the pace of justice. That decision stands as a reminder that our courts have never shied away from reform when the needs of justice demand it. My lords and ladyships, in conclusion, the Ghanaian people look to us not only to uphold justice, but to deliver it in a manner that is timely, efficient, and transparent. By leveraging technology, we can strengthen public confidence in the judiciary and truly make justice accessible to all. Let us therefore commit to a judiciary that is timeless in principle, but modern in method. Thank you for the honor and the privilege of joining you this morning for my first time as Attorney General and Minister of Justice for the opening ceremony of your annual conference. God bless you all, and God bless our homeland, Ghana.
Annual Conference of the Association of Magistrates and Judges of Ghana. As we gather here in this illustrious assembly of legal minds and judicial practitioners, we are reminded of the profound importance of the judiciary in our democratic society. Our judiciary is the bedrock upon which the pillars of justice, fairness, and the rule of law firmly stand. It is the guardian of our Constitution, the protector of our fundamental rights and freedoms, and the beacon of hope for those who seek redress and resolution. This annual conference serves as a testament to our commitment to upholding these principles and furthering the cause of justice in our beloved nation. It is my hope that the conference will afford us an opportunity to engage in thoughtful discourse, share best practices, and deliberate on the challenges and opportunities that confront us as stewards of justice. As we embark on these important deliberations, I would like to, with your kind permission, use this opportunity to draw our attention to the need for us to continuously work together on improving the delivery of justice in our republic. As members of the judiciary, our singular mission is to uphold the trust and confidence bestowed upon us by the public and to draw nearer to the ideals enshrined in our national symbols, ideals of liberty and justice for every citizen without any conditions or prerequisites. It is imperative that we recognize the weight of our responsibility as custodians of justice. We are the guardians of the principles that underpin our society, and we must ensure that they remain steadfast and unwavering. In doing so, we must always be guided by the unbending commitment to fairness, impartiality, and the rule of law. These principles are the bedrock of our justice system and should serve as the compass that guides our decisions and actions. In our pursuit of a more just society, we must continually strive for this transparency and accountability within our judicial processes, openness in our proceedings, accessibility to information, and a clear understanding of how justice is dispensed. will foster public trust. It is only through this trust that we can hope to break the divide between our institutions and the citizens we are duty bound to serve. Moreover, we must also be attuned to the evolving needs and concerns of our diverse citizenry. Justice must be accessible to all, regardless of their background, economic status, or any other distinguishing factors. Our courts should be places where every citizen feels heard and where their rights are protected with unwavering dedication. To truly embody the promise of freedom and justice for all citizens without any conditions or prerequisites, we must continuously educate ourselves and adapt to the changing landscape of our society. This includes remaining vigilant against any biases that might creep up into our judgments and ensuring our decisions reflect the ever-evolving understanding of human rights and social justice, and effectively managing our courts and cases. Despite the theme that has been chosen for the conference of this conference, the association president gave me the choice of speaking on any issue of national importance, and this permission I embraced with glee. As members of our society, there are certain issues we definitely cannot turn a blind eye to. Some of these issues are illegal mining, environmental degradation, and drug abuse. The large-scale clearing of forests for mining has destroyed natural habitats, disrupted ecosystems, and reduced the land's ability to provide essential services like water purification and carbon sequestration. Economically, while providing some income, the environmental damage and shift from agriculture has led to higher living costs and lower food production in affected regions. Land and contamination of our water bodies has directly impacted agricultural productivity, leading to low food production, food price hikes, as well as the health of the people in the affected communities. Over some period now, an estimated 4,726 hectares of land have been destroyed in 7 of the country's 16 regions, and 34 of its 288 forest reserves. The next subject I want to mention is drug abuse in Ghana, particularly among young people. A research I recently stumbled upon made grim reading and got me particularly alarmed. The results of the research concluded that there is a relatively high substance use among adolescents with a prevalence of 12.3%. It further revealed that 56.9% of the adolescents in Ghana abuse alcohol, while 26.4% abuse cigarettes. The two are the most common substances abused. Apart from alcohol and cigarettes, the results also concluded that 6.5% abuse tramadol, while 4.8% abuse marijuana. According to the research, the situation could actually be worse because typically substance abuse among adolescents in Ghana is often unreported or underreported. Most of us as judges and magistrates are used to quick fix drugs so that we get our business going. The most go-to drugs are diclofenac and ibuprofen, which are both non-steroid anti-inflammatory drugs commonly used in Ghana for pain relief. However, their misuse and abuse, often due to easy over-the-counter access, pose serious health risks. This is how they are abused. Frequent medication. Many people take these drugs without prescriptions, often in high doses, or often over prolonged periods. Some of us use it for minor or even non-medical ailments. They are often used casually for headaches and general discomfort, even when not medically prescribed or even necessary. Some even combine painkillers. The health risks of these misuse include stomach ulcers, internal bleeding, kidney damage, liver damage, and heart attack and stroke. So what do we do? What can we do as members of the judiciary? The judiciary's mandate and responsibility in relation to galamsey, environmental degradation, and drug abuse. As members of the judiciary, we are not policy makers, and we do not wield the enforcement powers of the executive. Yet our constitutional role is neither passive nor peripheral. We are the guardians of justice, custodians of the law, and interpreters of the nation's conscience. So our responsibilities in confronting these challenges include upholding the law. We must ensure that prosecutions related to illegal mining and drug trafficking and abuse are handled with seriousness, impartiality, and urgency. And I mean urgency. Where there is evidence, the law must be applied without fear or favor. No person, and I mean no person, regardless of their political affiliation or social status, should be immune from justice. Consistency in sentencing. There is a growing public perception that sentences for environmental crimes and drug offenses are either too lenient or inconsistently applied. We must work towards harmonizing sentencing practices to ensure proportionality, deterrence, and fairness. We must fiercely guard our independence from external pressures, be they political, commercial, or social. Our integrity is a bulwark that assures the public that justice is not for sale. A judicial innovation. In collaboration with the relevant authorities, there are plans to revive the specialized courts created during C.J. Wood's tenure and create or designate some more courts to deal with the increasing number of galamsey, environmental degradation, and drug-related cases. Swift adjudication can booster enforcement efforts and enhance public trust. Beyond our courtrooms, the judiciary, members of the judiciary must serve as moral compass. Through our judgments, speeches, and engagements with civil society, we must amplify the message that illegal mining and drug abuse are not only criminal offenses, they are betrayals of our collective future. We must also foster judicial training and capacity building to keep abreast of new methods of drug trafficking, cyber-enabled criminal networks, and the complex corporate structures often used to mask illegal mining operations. Furthermore, in our judicial community outreach programs, it will be ensured that issues of justice regarding the environment and drug abuse are adequately addressed. Now, a call to action. Colleagues, the fight against illegal mining and drug abuse cannot be won by the judiciary alone, but it cannot be won without us either. Let us not underestimate the ripple effect of our judgments, our diligence, and our courage. Every ruling grounded in justice strengthens the foundation of a law-abiding society. Let us recommit to a judiciary that is proactive, principled, and unyielding in the face of impunity. Let history remember that during a time of national crisis, the bench did not look away. These are the thoughts that I leave with you. And I want to end by congratulating each one of you for your roles in securing our Constitution, promoting harmony, and allowing citizens a path to justice and the resolution of disputes. I thank the organizing committee for the invitation for a successful conference. As we embark on this journey of knowledge exchange and collaboration, let us be reminded of the weighty responsibility that rests upon our shoulders. We are entrusted with the solemn duty of interpreting and applying the law, ensuring that justice is served impartially, and upholding the rights and dignity of every citizen who seeks refuge in our courts. I encourage each and every one of you to approach this conference with an open mind, a thirst for knowledge, and a commitment to strengthening our judicial system. Let us emerge from this gathering not only with new insights, but also with renewed determination to advance the cause of justice, uphold the rule of law, and safeguard the liberties of our fellow citizens. Together, as members of the judiciary, we can be the catalyst for the change we envision in our legal system, and by extension, in the lives of those we serve. I have no doubt that this conference will be a pivotal moment in our ongoing journey towards a more just and equitable society. With this, I declare the 44th Annual Conference of the Association of Magistrate Judges of Ghana officially open.